All right. Hello. Thanks for joining us. We are in session 4 of our 5-part webinar series. Today's session is called U.S. Dispute Resolution. There are 3 of us here today from Reinhart, Brenner, Van Duren. I'm Laura Brenner, and here with me is James Law and Andrew Price. And we'll just take a second to introduce ourselves. I am a shareholder in the litigation department, and I do commercial and business litigation, also business and commercial contract drafting. And I'm the chair of the firm's product distribution and franchise law team. And we advise all kinds of clients who do many, many types of business involving the distribution of products. James, can you introduce yourself?
Yes, my name is James Law. I'm an attorney in Reinhart's litigation practice. Prior to joining Reinhart, I had clerked for 2 federal judges, and so I have quite a bit of experience in the federal courts.
And Andy?
Yep, my name is Andy Price. I'm also in Reinhart's litigation group. I've worked on a variety of commercial cases, some of which have involved arbitration. Before coming to Reinhart, I worked as a research assistant for a professor at UW-Madison, and I was also a student attorney at the Wisconsin Innocence Project.
Great. Well, today we are going to talk about several modes of dispute resolution. First, we're going to be talking today about court litigation, and that's the type of litigation we have throughout the U.S. where matters are resolved in a formal court setting and decided by a judge or jury. We'll also be talking about an option to court litigation, arbitration, which are in a much more informal setting, usually agreed to by contract, where disputes are decided by a third-party neutral arbitrator, or perhaps 3 arbitrators. We'll also be talking a bit about mediation. Mediation is not a process that decides the case, but helps parties reach a resolution by using a third-party neutral called a mediator. So we'll be talking about each of those 3 modes of dispute resolution today. To give you a little overview of our program, we're going to spend the first part of the program talking a little bit about court litigation versus arbitration, kind of the pros and cons, what's good and bad about each, and comparing them a bit. In part 2, we'll talk about mediation, which can occur before or during a litigation or arbitration. So let's start by introducing some facts about court litigation. James, can you tell us about that?
Yes, so just to provide a little bit of background on court litigation statistics and some of the trends that are currently going on. Generally, case filings are down, and this is primarily due to alternative dispute resolutions such as arbitration and mediations. There are some other factors that are playing into that as well, such as a general aversion to the risk of litigation and the cost of litigation. The playing into related to this is that most cases will settle. Trials are not happening very much anymore. And it's been a growing trend for approximately 20 years now. Less than 2% of civil cases go to trial. So most cases will either settle or they will be disposed of in early court resolutions through such as a motion to dismiss early in the case or a summary judgment, and that will happen after evidence has been gathered in the case. And then the most recent stats on the length of cases in the federal courts is that in a trial court, the typical case will be about 8.5 months. This is a median number, it's not an average number, and it really will depend on the circumstances. Some cases, as I said, will be disposed of very, very early, perhaps in a matter of months, 2 to 3 months out from when the case is initially filed. Other cases may take as long as 3 years. And this is just trial court level. After the case is over, the parties will have an opportunity to appeal. The appeal process may take as long as 9 months, but that, again, will depend. It may depend on the complexity of the case and the docket of the appellate court.
Yeah, and I can say in my experience for complex business cases, from beginning to end, I've never had a court process go less than a year. And I've definitely had some go as long as 2 years. So I think it does depend on the complexity of the case, but I think the average is probably a bit longer than 8.5 months from beginning to end at least.
And another factor that may play into this is that there are some courts that are known as rocket dockets where their procedures are really geared towards making the case go as quickly as possible. That's not always true. There's other districts in the United States that they might not have the staffing levels and they may have a very, very busy docket, so it takes much longer.
So how about arbitration? Andy, can you tell us about that?
Sure. Just to contrast James' statistics about court litigation, I thought I'd provide a few arbitration statistics. First, one study found that 86% of corporate counsel are satisfied with international arbitration. So while there's a small percentage of dissatisfaction, it appears to be overwhelmingly preferred by corporate counsel. One study also found that a majority of parties find that arbitrators are more likely to understand the controversy than a judge. And I'll be discussing this throughout the presentation in relation to the expertise that arbitrators can have in arbitration. The last statistic relates to the length of arbitrations. One arbitration guide stated that, again, the median time frame for arbitrating claims involving $75,000 to $500,000 was 9.9 months. For claims over $1 million, the median time was 13.8 months. For claims over $10 million, the median was 15.8 months. This is an important statistic because arbitration is often known for being a quicker dispute resolution method, and this statistic shows that that's not always the case.
And that's been my experience as well, Andy. For arbitrations, they've tended to be a little quicker than court, but some of my arbitrations from beginning to end in a complex business litigation often last at least a year. So we wanted to talk about each of these modes of dispute resolution, and we came up with some topics, some overall topics under which we could talk about each one. So each mode of dispute resolution has distinctive advantages and disadvantages related to efficiency, flexibility, and predictability. So we'll compare litigation to arbitration with regard to each of those topics. Let's start with the first one. How about efficiency? Is court litigation efficient? James?
Yes. One of the first advantages for court litigation is that the cost of entry is relatively low. For example, the cost to file your typical case will be about $250. Keep in mind that the taxpayers are subsidizing the court system, so the parties do not have to pay for the cost for the staffing of the courts, for the judge, for the building, for the courtroom. All those costs are at taxpayer expense. There are certain trade-offs for that, of course. But then another advantage for court litigation is that there's the potential, as I mentioned before, of early case disposition. So, for example, a case may be disposed of before any discovery or evidence has been gathered in the case. So this can be something that is seen as an advantage. Another advantage is that plaintiffs have frequently a choice of forum. So a plaintiff may have the ability to file a case or a claim in a district that is close by. They may not have to go to a faraway forum that may be unfamiliar to bring a claim against somebody else. Another advantage is that the parties may, as I said before, be able to get quick and early relief. And what I mean by that is a party may be able to go into court for an emergency injunction and file a paper and obtain a hearing very quickly before a judge in order to get some kind of relief and maintain status quo before they've suffered some kind of harm.
Well, those are some good advantages with regard to efficiency for going to court. Is court litigation always efficient?
No, it's not always efficient. Litigation, as I mentioned before, may take many years to resolve. That can depend on the complexity of the case, how many parties are involved in the case.
And it can just depend on how fast or slow the judge is as well, correct?
Yes, exactly.
And how busy the judge is.
How busy the judge is. For example, in my experience, and the judge that I had worked for, some decisions took months to come out, and other decisions were relatively quick. But that all depended on, again, on the complexity of the case, how much evidence there was to review that was submitted by the parties. So it really could depend on many different things. Another disadvantage is that attorney's fees and expert's costs can in some cases exceed the recovery. So for example, you may have a $50,000 case, but your attorney's fees and the experts that that are needed to successfully get a recovery may amount to $60,000, something that is above and beyond what the case is worth. So that's an important factor that needs to be considered, and it can be a disadvantage.
That's one of people's biggest complaints, is that the cost of litigation can exceed the amount at issue.
Right. Another disadvantage is that the discovery, and what I mean by discovery is the process by which evidence is gathered by the parties in the case. Discovery can be very invasive. It can be very burdensome and expensive. Invasive in the sense that the opposing party has a presumptive right to explore the evidence that you have to support your claim. And that can be a very, very invasive process. It can be burdensome to supply go through many years of documents and to provide the documents that are relevant to the case to the other party. And that process can be very expensive. One of the hot topics right now is the issue of electronic discovery. With the growth of digital information, there's more information that is being stored, and so there's more information that needs to be gone through. So some certain kind of cases that I've been involved in have more than 60,000 documents that are all electronic. And it can be a very expensive process to obtain the electronic information and to go through the electronic information.
Well, and when you're talking about things like emails and other electronic information, you could be talking about millions of pieces of information, and to go through all that can be expensive. You may have to hire a third party.
That's exactly.
Is that one of the biggest problems right now, is that it's just the cost of going through and all of that electronic information?
Yes, and this is a relatively new area as well. And one of the hot topics right now is predictive coding, and that is a system where you go to an outside vendor, and they may be able to have some kind of a software system to search the data rather than traditional model of document review with a team of attorneys sitting in a room and laying eyes on every single document. And with the growth and the amount of electronically stored information that there is, that can be a very, very impossible task. So there's been a shift in focus to try to search through the documents.
So, but we haven't come up with a perfect solution yet to make the deposition and document discovery process less expensive yet, have we?
No, there's a big debate, and there are no easy answers.
So how about arbitration as opposed to court litigation? Is arbitration efficient? Andy, can you tell us about that?
Absolutely, Laura. In some respects, yes, and in some respects, no. Some of the advantages of arbitration are that it may be cheaper. Arbitration may have less motions, for example, less appeals, just a less of a focus on some of the type of procedures that you need to adhere to in court, and that can save the parties some money. Also, arbitration can be quicker. Again, the flexibility of the arbitrator's schedule, the party schedule, may make the process quicker, and the arbitrator may not require or even permit certain types of motions or other procedures that court would, and thus kind of streamline the process. The last thing I would note as far as an advantage of arbitration is that arbitration is a creature of contract. And by that I mean parties can contractually agree to a lot of aspects of arbitration. For example, about the procedures that will govern arbitration or the timing of it. And their ability to agree on these things contractually can make it efficient sometimes.
That sounds good. Is arbitration always efficient?
Not always. Unfortunately, it's not always quicker, cheaper, or less contentious. Sometimes there can be disputes about the process or the contractual agreement. And also, it can be more expensive because parties may use 3 arbitrators and thus increase the fees for arbitration.
Whenever you have 3 people deciding instead of 1, it probably takes a bit longer and costs a bit more.
Absolutely, especially in arbitration when the arbitrators might be highly trained experts, so the fees can be expensive sometimes. Another disadvantage of arbitration is that in relation to efficiency, is that it may not work best in complex cases with multiple parties. Sometimes arbitrations aren't able to handle these cases well because the parties didn't anticipate the amount of parties to be involved or the certain disputes. Often court has rules and procedures to deal with these complex situations. The last thing I would note is that courts might be better at giving quick, equitable relief, like injunctions. And I was wondering, Laura, I know you've got a lot of experience with injunctions and quote-unquote equitable relief. Can you describe maybe why that would be important to maybe a dealer or someone in your area of law?
Sure. I mean, many times when we're in a commercial business situation, we need some emergency relief. Perhaps someone's going to terminate a contract or take other action that could damage you irrevocably, and you want to run and get some relief quick to stop them. Courts are set up for this. You can run down the street and file some papers and often get a judge very quickly who are used to these type of procedures. In arbitration, sometimes it may take longer to start the arbitration or to get the arbitrator or arbitrators appointed. Now, some arbitration associations have tried to address this problem by putting into place some emergency relief rules that you can get some relief quickly even in an arbitration situation. But historically, courts have been better set up and more adept at granting emergency relief than arbitrators. So we've got the next question. I don't think we've come to a perfect resolution on which is more efficient, court or arbitration. We've got some pros and cons for each. How about formality? Court is more formal than arbitration. Is that an advantage or a disadvantage? James, let's start with court litigation. Is it too formal?
Well, I wouldn't say that it's too formal. At least then I have a biased perspective, having had experience in the courts. But one of the advantages of the formality of the court is that there are many rules that provide certain kinds of predictability. For example, rules of procedure and rules of evidence. Another advantage is that there are broad discovery tools that are available to obtain evidence, and that provides for a predictable process by which evidence is going to be gathered in the case. As I mentioned before, there's evidentiary rules. The evidentiary rules are important in courts because you can exclude less reliable forms of evidence. For example, hearsay evidence that might be possibly considered in other kinds of settings like mediation or arbitration. Another advantage of the formalities of the court is that there is a written record. And what I mean by that, there is a court reporter that is taking down testimony, and judges' decisions, if they are written, are typically issued by an order, and that is publicly available. And that can be very, very important in the case. Because there is a written record of the court, this is advantageous because parties, after the case is over, have the opportunity to appeal. So this means that a judge's decision or a jury's verdict can be reviewed by an appellate court, and certain kinds of areas of law or areas of evidence can be overturned. So those rules of formality can be seen as distinct
So while the rules kind of can vary by jurisdiction and by court, there's some consistency there. You're in a courtroom. The rules of evidence and rules of civil procedure tend to be very similar or the same from court to court. There's some advantages to having that consistency. And then the appellate review of a court's decision obviously provides some consistency and some formality as well that we're used to.
Yes, and attorneys typically become very experienced in their local courts, and this can they have a certain level of comfort with the formality of courts.
So we attorneys get comfortable, and that can in court, and that can be an advantage. But is that comfortable for everybody?
No, I would say that's not always comfortable for everyone. One of the disadvantages of the formalities, and because there are lots of rules to follow, people who are unfamiliar with those rules can be very intimidated by the process. And also, you are in a courtroom, you're before a judge that you have to sit, you have to stand, and each judge might have some kind of peculiar preferences to follow. So that those can be very, very intimidating for people who are unfamiliar with the process. Another disadvantage in the formality is that the judges have less flexibility in fashioning a resolution of the case for the parties. Judges, their primary focus is to resolve a dispute according to the law rather than what the judge thinks is fair. The judge is constrained by what remedies are legally available, and so the judge loses flexibility in fashioning a remedy that might be best for the parties. Another disadvantage is that hearings and trial are open to the public. This is, as I said before, the courts are provided at taxpayer expense. So the presumption is that the court records, the court orders, and the evidence that's presented to the court are going to be public. So the parties lose confidentiality, and that can be seen as a disadvantage for parties that might not want to reveal certain kinds of information.
Now, if there's confidential business information or just confidential private information that is part of the court proceeding, there are ways that you can ask the judge to protect that information from public disclosure, but that's the exception, not the rule. Is that correct?
That's exactly right. There is a presumption that the information that's filed with the court will be publicly available. That presumption can be overcome. For example, trade secrets. But you have to convince a judge that you have a trade secret, that your information should be protected. So that can be a disadvantage. Another disadvantage for the formality of the courts is that under the American rule, each side will pay its own attorney's fees. And as I said, we mentioned before that the cost of the claim it might not be worth it in comparison to the attorney's fees that are necessary to successfully recover that claim. There's exceptions for that where a statute or a contract may provide for attorney's fees in the sense that you can recover the attorney's fees that you incur for the litigation, but that's the exception and not the rule.
And that's one of the biggest complaints again about court is that it can be expensive and the cost and fees can exceed the amount at issue.
Right, exactly.
Also, court has a lot of formality to it. Can be advantageous or disadvantageous in a lot of ways. How about arbitration? Arbitration is known for being less formal than court. How about what about that issue, Andy?
Certainly, there's certainly some advantages and disadvantages to the informality of arbitration. First, picture being in a conference room usually with someone, an arbitrator, sitting at equal height, not on a podium or sitting way above you. Overall, I'm just trying to convey it might be a less intimidating atmosphere. So in and of itself, the process might be less intimidating. Some other advantages of arbitration in regard to informality are the schedules, again, of the parties and the arbitrator might be more flexible. And again, an arbitrator may not have an overloaded docket, and so people can accommodate their schedules. Another advantage is that arbitrators may use a less strict form of court rules or no court rules at all. And so this reduces some of the intimidation by attorneys and parties sometimes in preparing for these or worrying about how a procedure will play out.
I've had it happen both ways, Andy. I've had arbitrators who will apply the same rules as a judge with regard to procedure and evidence, and I've had other arbitrators say, we're going to apply none of those rules. I will listen to any evidence you have to offer, offered in any way that you would like, and I'll decide after that. And so I've definitely seen it both ways, and it can depend on the preference of the arbitrator or arbitrators.
Absolutely. So it's important to keep in mind that if you have a relaxed usage of the rules or no rules at all, certain types of evidence might be used that may not be allowed in court. Another advantage to informality, the informality of arbitration, is that arbitrators generally have a greater flexibility in fashioning awards. James touched on this by discussing how judges are sometimes limited. Laura, I know not only do you litigate, but you also have experience in drafting these arbitration agreements. Can you discuss maybe some examples of limitations on awards?
Yeah, when we draft arbitration clauses in contracts, sometimes we'll put limitations on the award of the arbitrator that both parties will agree to in advance. For example, sometimes both parties will agree to exclude certain types of evidence, like punitive damages or consequential damages or things, or lost profits and things like that. And later, before, sometimes during or before the arbitration, we can agree to that the arbitrator will give an award in a certain way, like will not exceed a certain amount, or will not go below a certain amount, or will have to pick one of two specified amounts. So there is a great deal of flexibility and a little bit more informality sometimes with regard to an arbitration, especially if the parties agree.
Absolutely. And so that's a major advantage of the informality of arbitration. And the last point I'd like to discuss is arbitrations can be private and confidential. So James touched on the public nature of court. That's not always the case for arbitration. And this can be very important for companies or individuals that may not want their disputes to be known to the public. So it's a very, very important advantage of the informality of arbitration.
I think people see that as one of the most important advantages of arbitration, because it is helpful to have a dispute resolved in private, and so that you can keep confidential business information confidential.
Absolutely. But there are disadvantages, of course. The informality of arbitration can create disputes and confusion among the parties. And along with that, the relaxed rules can also add to this confusion and the disputes among the parties, because it's just not as clear as the formal court system sometimes.
Yeah, I've definitely, we've had many arbitrations where we have been slightly frustrated by the procedure or the process that the arbitrator used, and it was at the discretion of the arbitrator, so there wasn't much that we could do about that, whereas court, we know what to expect. Sometimes with an arbitrator, you do not.
Absolutely.
So with regard to formality versus informality, there are advantages and disadvantages with regard to both court litigation and arbitration. No perfect winner here.
No, it depends on the case.
Right.
Well, let's talk about predictability then. Let's start again with court litigation and predictability. James, what are the advantages and disadvantages with regard to court litigation and predictability?
Well, to begin with, Laura, one of the advantages, as we had mentioned before, was that the formal rules of procedure and evidentiary rules provide some guide for attorneys in how the process will be in the case. It doesn't necessarily mean that you did exactly how a judge will rule on a piece of evidence, but it does provide some level of comfort in knowing what those rules are. Another advantage is that public decisions are precedential. They provide for precedential authority in that appellate decisions are public, and so we as attorneys can look to appellate decisions on cases that might be similar to ours that have been litigated in the past, and that provides a guide in planning and future conduct. In that, by comparing it, you may know how a judge in a future case may rule. It's not always the case, but it provides some level of comfort and predictability.
That's true. So we don't always know how our judge is going to rule, but it does give us some good sense. We can help assess the risk of trying a case in court because we can try it. These published decisions and their precedential value helps us evaluate the risk and help us try to determine what the judge is going to do in this case.
Yes, and another advantage I would mention on that is that your particular judge that you may have in dispute, his decisions are publicly available. So you could go back and see what their decisions are and how they ruled to provide some insight into how that judge may think about certain kind of issues.
So our court litigation process does give us some predictability. It's not perfect, but it does give us some level of predictability. Are there any disadvantages?
Yeah, one of the disadvantages is that judges are generalists, and what I mean by that is they do not have any kind of level of subject matter expertise frequently. So you may have a very complicated dispute or a complicated subject matter. The judge may not know anything about that particular piece of technology that you have or the contract, and so that can be a disadvantage for you in that you have to educate the judge on so they understand your case. The same is true with juries. Juries are selected from a broad pool from the general public. The juries will not have a expertise in your subject matter. That's generally true. You may have a juror by happenstance that has some familiarity, but that's not that can't be relied upon. Another disadvantage is that the cost of litigation can be relatively unpredictable. You don't know if the judge will dispose of the case very, very early, and so your costs will not go up very high. But on the other hand, you may have a case that is very, very complicated and draws out for years, and there may be many disputes about evidence that should be turned over in the case, and that can lead to unpredictability in the cost of the litigation.
A lot of litigants often ask attorneys to tell them in advance how much a court litigation will take from beginning to end, and that is really hard for lawyers to sometimes do because of the unpredictability of court litigation.
That's absolutely correct.
With regard to predictability, what about arbitration? Are there advantages and disadvantages with regard to predictability in arbitration?
Yeah, certainly, Laura. There's points on both sides, and it can kind of make you feel like you have to stare into a crystal ball, like my little picture at the bottom of the slide here. To start with the advantages, parties, as we've already discussed, can agree on a lot of things regarding arbitration. You can agree on the arbitrator's qualifications, the location, rules, and the law to be applied, and even on limits concerning the award, which is something Laura already discussed. And I would just emphasize how important it is that sometimes the parties can require an arbitrator or agree that an arbitrator will have a subject matter expertise, so you don't have kind of the generalist judge that James was discussing. Of course, if your arbitrator has that expertise, it might make it more likely that the process will be predictable or the outcome will be predictable. Some disadvantages regarding predictability in arbitration. Arbitration has a kind of a wide scope of discovery sometimes. There can be limitations on certain forms of discovery, or there can be a full spectrum of discovery. So it's tough to predict how much that's going to be allowed and how that's going to affect your dispute.
Oftentimes that's up to the arbitrator. Some arbitrators will allow discovery, just as if you were in court, and other arbitrators will allow much more limited discovery. So it can depend on your arbitrator, and that can make it less predictable.
Absolutely. Another disadvantage is, as with most things in life, you can have a bad arbitrator, and that would obviously affect your predictability or the predictability of your dispute.
Just like there are good and bad judges, there are good and bad arbitrators sometimes.
Absolutely. Another point is that outcomes are often difficult to predict in arbitration because arbitrators have such a large amount of discretion. And we briefly touched on this, or James briefly touched on this when discussing precedent. So judges may be forced to apply certain rules or have certain interpretations of law based on how other courts have ruled and binding interpretation of the law. Arbitrators generally have more discretion, and so this might lead to a less predictable outcome. To add on to that, the process for overturning an arbitration is it's a higher standard. So reviewing judicial decisions, there's certain standards to appeal and to overturn a quote-unquote bad decision. In arbitration, that standard's even higher and more difficult to overturn.
You can only overturn an arbitrator's decision in general. Again, the standard's very high for you must show that the arbitrator was biased, or you can show that the arbitrator's decision was constituted a manifest disregard of the law. Not just a disregard of the law, a manifest disregard of the law. So arbitrators typically are not required to follow the law or any rules the way that judges are. And so that can make the process much more unpredictable. You may get a decision that isn't anything that you predicted, and now you have virtually no appellate rights.
Sure. And I'll just mention one thing. Not only is the outcome of the initial arbitration less predictable, but it's the mindset of the arbitrator might be more different than a trial judge. James, do you have any insight into how a judge might view an appeal of their decision?
Yeah, in my experience in the judges that I had clerked for, the judges were much more cognizant of the fact that their decisions could be appealed by the parties, and that errors of law and errors of evidence would be corrected. So judges really press upon the judge to be very, very careful in the decisions that they render, because judges, by and large, do not like to be reversed. They want to get it right the first time, and so the more confidence that you have in your judge to get the decision right, the parties will be more hesitant to appeal in the future.
Thank you. The last point I'd like to mention is that unlike court decisions where they're published, and as James mentioned, you're able to review these decisions, you're able to review how a judge may interpret certain issues, arbitration is largely private. So it's much more difficult to get a sense of how that arbitrator may decide an issue, thus affecting the predictability of the process and the outcome.
And I wanted to make 2 points on that. There are some arbitrations now that are becoming public, that are published, but they're few and far between, so very few. So it is hard to find out how an arbitrator, if there are any trends in how an arbitrator decides things, unlike a judge. So that's a very good point. And there are some arbitration associations that are instituting appellate procedures, but for the most part you must agree in advance to have an arbitrator's decision reviewed. So with regard, we've examined now efficiency, predictability, and formality of the court litigation and arbitration systems. Have we come to any conclusions about which is better?
I think, Laura, the person or individual or a company is in a situation where they have a dispute or they need a dispute resolution mechanism. I think it's important to look at the type of the case, look at the specific facts of that case, and see, weigh these advantages and disadvantages, and also look at what is important to that party or to that company, because certain processes might be more cost efficient, or the outcome might be binding, or have certain effects that a party might find more or less favorable than a different process.
Yeah, in my experience, the judges that I have worked for, judges by and large they're very good as far as the quality of the judges in the federal bench that I had experience with. So I think that there's a lot of confidence in the ability of the judges, even though they might be generalists, that can be seen as an advantage, or because the judges have limited experience, that might be seen as a disadvantage in certain kinds of disputes.
But just like there are good and bad arbitrators, there are good and bad judges and all over the U.S. and good and bad court systems. Some are overloaded, right, which makes, unfortunately, gets in the way of a decision. So there's good and bad things about being in court as well.
Yes, and I think another advantage that we have to weigh is that discovery in courts is broad-ranging, but disadvantage is that discovery, as we mentioned before, can be expensive and burdensome. So although you have more ability to gather evidence to assess the strengths and weaknesses of your claim or the other side's claim, you have to weigh that against the cost.
Those are important points. When I'm talking to companies about whether or not we would like to agree in a contract to have an arbitration clause, or whether we will take the risk that we're going to resolve a dispute in court, there are a couple things we'd like to consider. One is, what's the likelihood you'll be in a court in a geographical area or another country that you're uncomfortable with? If that likelihood is bothersome to you or scary to you, you may want to agree on arbitration because it provides predictability. You can pick a city that is convenient for most and an agreed arbitration association. If you have cases that might happen all over the world, or a high chance of litigation or repetitive litigation, or a lot of it, you might consider an arbitration clause that allows you to consolidate cases all in one place, or have them tried all in one place over and over again. So there's things you want to consider. On the other hand, you may want to consider whether the type of disputes you might be in, you would have some advantage in having open discovery, much more broad discovery, or more predictable rules of court, where you can get some dispositive motions or early resolutions. So I consider those things too. So what I do is sit down with clients and talk about the pros and cons of court litigation and arbitration, and try to predict the types of disputes that might be coming and where it would be most advantageous to have those tried.
I think, Laura, I think you would agree that it's important, because arbitration is a breach of contract that individuals and companies should be mindful of contracts that they sign, because they may already include, or parties may try to bargain for an arbitration clause, and that may affect what avenue you're able to go down. So it's important to review those agreements and discuss these things ahead of time if you can, so that you have different avenues available later. That's
absolutely true. All right, well, we've talked a lot about court litigation and arbitration. Let's next, for our final portion of our program, let's talk about mediation. What is mediation? Mediation is the process by which a neutral mediator helps the parties try to resolve their dispute. Now, a mediator does not decide disputed issues like an arbitrator or judge. A mediator may offer opinions about the strength or weakness of a position, but they really don't decide the issue. A mediator may offer suggestions for how to settle a dispute, but again, they are not the decision maker. Let's talk about whether mediation is required. Mediation between parties is usually voluntary, but that's not always the case. James, isn't it true that some courts require mediation?
Yes, that's true. Some state courts will require mediation as part of bringing certain kinds of claims. In the federal courts, on the other hand, mediation is not required, the voluntary process, although judges frequently will encourage mediation and encourage parties to try to reach the settlement of the case.
So sometimes, even if it's not required, I've had a judge who twist my arm and get me to go to mediation. So while it wasn't required, it was required. All right, so Andy pointed out contract provisions and with regard to arbitration clauses. But some contracts can also require mediation prior to arbitration or litigation, correct?
Absolutely. Parties can often agree to a multi-step kind of process to resolve disputes. And sometimes one of those steps is mediation before arbitration or before court, or just mediation itself.
Absolutely. In fact, sometimes contracts can say that parties must engage in a mediation process prior to even filing a demand for arbitration or a claim in court. Sometimes that helps. It helps, again, it helps avoid the expenses of going to arbitration or court. So finally, usually mediations, and I think most attorneys will agree on this, mediations are usually only successful if both parties are ready to mediate. So it's best if it's voluntary. It does not help to go to a mediation process where one party is just not going to budge or compromise at all. So when do we mediate? You can do a mediation really at any time, and I've done them at all kinds of times in the within the process. So sometimes we can do a mediation before a formal case is filed. Sometimes we can have a mediation after a case is filed, but before either party incurs substantial fees or costs. And oftentimes we can do a mediation after the parties have had time to investigate the case or file motions. And sometimes we even wait to do a mediation until the eve of trial or the eve of the arbitration hearing. Now there are pros and cons to each, obviously. James talked at the beginning of our program about how there are less and less people want to go to court these days.
That's right. Less than 2% of cases go to trial. Frequently, cases will settle prior to trial, and mediation is a key part of this.
Exactly, and more parties seem to be willing to do that. They get reasonable a bit earlier, perhaps because of the cost and fees associated with the court proceeding.
Right, and judges frequently will encourage the parties to try to reach a settlement of the case. And my judge that I had worked for, he had a saying that all sins of litigation are washed away with a settlement. So there really is a strong preference for parties to try to work out the dispute on their own.
And I would add that, as Laura mentioned earlier, how arbitrators and mediators might have the ability to be flexible with the award of court litigation might not have that, so the stakes might be higher. It might be an all or nothing kind of proposition, which might encourage parties to mitigate that risk by engaging in mediation or arbitration.
Yes, that's exactly right. That's one of the factors that's frequently cited in the downward trend in trials in the country and the courts. Because of that aversion to the risk of litigation, having it be a all or nothing proposition.
And there are advantages and disadvantages to doing mediation early as opposed to later in the process. When you do it early, you save those costs and fees that you incur in both court and in arbitration. On the other hand, you don't know as much about the other side's case. So you may feel like you have a disadvantage in negotiations, and if you just knew more, you'd have more knowledge and feel more comfortable that a settlement was fair. You'd be able to assess your risks better if you had more information. That's why some parties prefer to conduct mediation later in the process, at least after some information between the parties has been exchanged. On the other hand, that leads to additional costs, of course. So there are advantages and disadvantages to conducting a mediation early or later in the process. So what is the mediation process? Typically, the steps are you, of course, sign a mediation agreement designating the mediator and perhaps some rules, like where the mediation will take place, when it will take place, perhaps what kind of written information the parties will exchange or give to the mediator prior to the process. The next step, for the most part, is you follow the mediator rules. You typically, it's not unlike an arbitration in that it is often conducted in an informal environment, in a conference room. The mediator sometimes gets the parties together jointly to discuss some things. Oftentimes, though, the mediator will separate the parties into two rooms and go back and forth and talk to each and try to help them reach a resolution. We refer to this as shuttle diplomacy. They shuttle back and forth all day and try to help you reach a resolution. And at the end of a mediation, typically the parties will sign a written agreement, a settlement agreement, and hopefully that resolves the entire dispute between the parties. Sometimes a mediator will have a form settlement, or otherwise the parties will come up with it then. Sometimes you leave the mediation that day and prepare a more formal settlement agreement. So it's an informal and flexible process that way. And so what is the secret to a successful mediation? You guys can weigh in as well, but my thoughts on that, first of all, is both sides need to be ready to negotiate. Again, if you have one party that wants to settle and the other party is not ready, it is very unlikely that the mediator can help you reach a resolution. So both sides really need to be ready and willing to talk.
Laura, I know you've got a lot of experience with not only court litigation, but also arbitration and mediation. Can you tell me the different mindset you might have, if any, when you're possibly going into a mediation versus an arbitration in court, or is there a difference between all three, or do you have a similar mindset for all of them?
You know, there's definitely a different mindset for each, but I would say that the one thing that you want to be for all three is prepared. The person that is most successful in a litigation and arbitration, but also a mediation, is that person that has prepared with their clients. Have you thought about the arguments that are going to be made? Have you thought about possible resolutions that you can propose? I think especially if you have prepared and thought about it in advance, and the client has prepared and thought about it in advance, it's the best way to handle really all three of those procedures. Many people go into a mediation, though, Andy, and don't prepare at all. And because they want to save the costs and save the fees, that is probably not the best thing to do. You want to go in perhaps not incurring all the costs and fees that you would, of course, in a litigation or arbitration, but you want to take some time to prepare and understand your case and try to understand the other side's case, which goes into the next bullet on our PowerPoint, which is try to go into the mediation with a good understanding of the risks and rewards of settling and not settling. James, did you have a point?
I just wanted to go back really quickly to the preparation. Isn't it true in terms of the preparation that you need to ensure that the other side is someone with authority will be present there, that they can enter into a settlement?
Absolutely, yes. In fact, a lot of times people make the mistake of not having someone at the mediation who can make the decision with regard to settlement. Right. With regard to making a payment or accepting a payment or entering into an agreement, it is crucial to have somebody with authority at the mediation who's present. There's no doubt about that. That's a very good point. And finally, and similarly, it is really best to have a really good mediator, somebody that can really help the party reach a resolution, that can suggest settlement options that maybe you haven't thought about, and can help both parties understand those risks and rewards of settling and not settling. Sometimes it's great to have a third-party neutral tell your client or to tell you about the holes they see in your case that helps you become reasonable. And likewise, it's great to have a third-party neutral tell the other side that they may not be successful as well, and that helps make them more reasonable as well. And usually, mediators, how do I get a good mediator? One is you ask, you get referrals. You talk to other attorneys that have had that mediator before. And often mediators are either experts in their area. You can get a great expert in a complex case that knows the area that you are in, that's in dispute. And many, many times, former judges make the best mediators. James, you probably you've known some judges, and they're terrific on the bench.
Yes.
You can probably see how some of them, at least, might be terrific mediators.
Yes, in the court that I had clerked for, in the federal system, magistrates will usually play the role of the mediator. They do not have to be selected as a mediator by the parties, but they have lots of experience in mediating disputes, and so they will frequently play that role on the request of the parties. And the judges are very happy to refer the parties to mediation before what's called a magistrate judge. That can help them try to reach a resolution of the dispute.
And mediators are usually the cost. The mediators are always unbiased. You always want an unbiased third party. And usually the cost of the mediation and the payment to the mediator is split equally between the parties. And in some of our federal courts will provide a magistrate judge free of cost to the parties to help mediate.
That's absolutely right, and that parties will, because of that, will frequently go with the magistrate judge because the cost of the mediator is essentially subsidized by the taxpayer for providing the court system. And mediation is an important way for the courts to encourage the parties to pursue mediation by because the magistrate judge's fee. Their services and their time is free to the parties.
One of the points I wanted to revisit that Andy had brought up either is, do I include a requirement for mediation in my contract? The answer is sometimes, again, as we've said several times today, sometimes yes and sometimes no. Sometimes requiring mediation, of course, can help you avoid all those costs of arbitration and litigation. So oftentimes it works, but sometimes forcing a mediation just doesn't work at all. Again, both parties really need to be ready to negotiate. So requiring people to mediate before they're ready may not be successful. So you have to consider that as you're deciding whether to require mediation in a contract or whether to just suggest it when a dispute arises. Finally, if you have any questions about anything we've talked about today, please feel free to contact your Reinhart attorney, the one that you know the best, or any of the presenters here today. It's been our pleasure to talk to you about litigation, arbitration, and mediation, and we thank you for listening.
Thank you.